Morning, everyone. Thanks for joining us. Today is also going to be a very exciting day because we have a very prominent lawyer, Ching Leong, joining us to share about the PDPA compliance in 2025. Now, we have worked together with Ching Leong before, so we also talk about Cybersecurity Act 2024, and this is the part of the series that we continue to share with the public about Personal Data Protection Act and why is it important to businesses. So today, I'm seeing that there are still participants joining, and one of the best practices we encourage everyone to follow is that don't use an AI agent. Like use just if you are intended to attend the webinar, just join us and then post questions live, and then we'll be happy to answer your questions. Okay. So topic for today will be as such. We talk about the Data Protection Act 2010. So if you look at the timeline, right, it's kind of amazing. The PDPA has been with us more than 10 years already. So I'm not sure if anyone feels it. It has already been 10 years. And there were new amendments happened in 2024. So today we're also going to talk about the new amendments. And more importantly for businesses, what should we pay attention to? What should we look out? What are the implications to us? And some of the best practices. And then we're going to talk about our data protection officer outsourcing service and Q&A. So background about myself. Today I am coming from a very cybersecurity technical background. I'm not a lawyer, definitely not a lawyer. So today the heavy lifting is going to be done by Ching Leong. So my role here today is pretty much on sharing my experience in data protection, in cybersecurity, security, defense, and more importantly, I will also play a role as a business to ask Ching Leong questions on behalf of everyone here. And there are some questions, if you think that you want to ask also, please feel free to put into the chat box and we'll be happy to share with our lawyer here, and then we get our questions answered. So I come from a very technical background, so as you can see from the brief intro here, and even until today, I'm still very much impassioned in cybersecurity. Cybersecurity is a very interesting field where every day you get to see different things, you get to learn different topics, and you get to see how hackers evolve and how organizations, need to find ways to defend itself. So it's an ever-going battle between the good and evil. So cybersecurity is very interesting, and unfortunately, I think this is again is a forever cat and mouse chase game. We are always need to stay ahead of hackers. We always need to learn what are the tactics. So that's why data protection today is also very relevant. Today, if we have experienced a data leak, right, it's also signifies a lot of things. It also means that we have failure in our policies, in our procedures, in the way how we manage information. So it's not merely just a data leak per se. So when we look at cybersecurity incidents today, it actually has a lot of implications. So today I'm going to share with you some of my experience in cybersecurity protection as well. And then I'll pass to Ching Leong.
Hello. Well, I mainly do four things: IP, IT, cyber law, and franchise and licensing. I've been in this industry for about 20 years. I have experience in dealing with hacking, data breaches. When the law, even before the PDPA came about, I was really involved in data privacy. So previously, I was also involved in the compliance for telco, insurance, and many other companies when the law first came about. So that's all for me for now.
Thank you, Ching Leong. So this series of webinars is brought to you by LGMS. So we are a cybersecurity assessment firm, currently listed in Busan, Malaysia, for the third year. We are still take pride in ourselves being the neutral and objective and considered largest security assessment firm in the country. So we'll continue to provide professional services to the client locally and regionally. So let's go into the topic, Personal Data Protection Act. Okay, so this is a first glimpse of what is this about for Personal Data Protection Act. So it's about personal data, again, that's relating to how we process, store, and protect the data. So I have a question here, Ching Leong. Perhaps we can start by asking you questions. So in terms of PDPA perspective, right, what do you think is important for business to know? The first thing for business to know, what kind of business is relevant to this, by the way?
Okay. Well, any business in a commercial transaction, there are certain rules that you need to comply with. Among this rule is what we call the seven principles. But later we'll go through it. But most importantly is that consent is required to do anything. It's pretty common sense. What do you want businesses? How do you want businesses to deal with your data? There are a set of rules, actually internationally well-known rules across a lot of countries. They all comply with the same rules. Essentially, is you want to do anything, you need you need consent. And how consent? It can be written consent. It can be implied actually, but in a way, those implied consent has to be recorded. But how do you record implied consent when it is not? How do you record it? So it can be through conduct. So, for example, if I do not respond to you, you did not nod, but in a way, it signifies that you consented to it. That can be a form of a recordable consent. So essentially, that is PDPA.
Okay, meaning that let's say if I'm using an app, all right, and then app keeps pops up, and then the pops up will close by itself. Let's say 1 minute later, if I don't do anything, if it closes 1 minute later, and then of course the pops
Mm,
up will tell me that they want to get my consent to use my data, personal data, and all that. And if I do not respond to it, and the pop up window close 1 minute later, it also signifies that I agree with the terms, right?
yes. Yes. So
Okay.
subject to what is written there. So if, let's
Mm,
say so there's an opt-in and opt-out provision. So if you
mm,
opt in, for example, you will need to say that, click on it and say, okay, I opt in. And or if you are the opt-out position is that you do not click on it, do not do anything, then you will be deemed to be part of it. So opt-out is essentially say I don't want to be part of it, but you need to signify that you do not. So in
mm.
Malaysia is neither is it both parts are acceptable. But in certain countries, where opt-out is required, opt-out is not recognized, but some opt-in is the mandatory provision. So you've got to see where you are when you deal with this type of consent.
Okay, so let's roll back to the very beginning of the PDPA, right? The PDPA applies to what kinds of company? Let's say if I'm a manufacturer, am I subject to PDPA? Uh,
Yes, every company, I would think that every company dealing with commercial is in a commercial transaction has to comply with PDPA because other than your customers who may be individuals, those customers, let's say, well, businesses also who also have individuals, which you will need to ensure you take care of the data. Two is your employees' data. The PDPA applies to your employees. So even assuming that you are a manufacturer, you only deal with businesses, you don't deal with customers' data, or you don't deal with very limited customer data, but you would have a lot of employees. So the employees doesn't matter whether they're foreigner or local, the PDPA would apply to them. So there are a set of rules which you need to comply with when you deal with employees' data. But across
mm,
the board, employees' data, customer data, this basic SAM principles still apply.
okay, well, this is also brings on to another question because assuming if I'm SME, I'm running a business, I have less than 10 employees. All right, I have their, of course, their personal data in the HR system, and will this PDPA applies to me?
Yes, it applies whether or not you have one employee or 100,000 employees.
Mm.
There's no numbers to it. So long you process any personal data, the PDPA will apply.
Okay, that's very clear now. So,
Mm.
in summary, I would say any organizations today, as long as you have personal data, regardless whether it's employees, customers, you still fall under these
Correct.
categories,
So
right?
then there is also some how do you put it? Some confusion whether the PDPA would apply, let's say, to a building. Whether they have a shopping mall, customer comes in and then there's CCTV recorded of the customer coming in. There will be, for example, you do not sign any agreement with them, you do not sign anything with them, but what shopping mall has been doing is they have notices outside to tell you that I'm gonna have CCTV, I'm gonna record your information. If you do not comply, if you don't want it, don't come in. So something along those lines.
Mm,
So in those circumstances, also the PDPA would apply. So
mm,
in respect of, let's say, a condominium also, let's say a strata management body, your JMB, your management committee whether the question the PDPA applies or not. So there are two schools of thoughts. One would say that because they are not in a commercial transaction, the PDPA does not apply. So in a way, is you do not need to give notices, you do not need to take care of data and so on and so forth. But PDPA sets out a mandatory rule for those businesses, but it does not mean that other non-commercial entities do not need to follow. So you should the management committee or those strata management body should comply with the PDPA to ensure that they do not get caught in the event that there's a data breach.
Yeah, that's the interesting point, Ching Long, because nowadays when we go and visit some buildings, some offices, right, we're required to present our personal data, IC and the pictures, even pictures get taken. Our IC contains our home address, IC number. Now, my question is that if these buildings are not into any commercial transactions, right, when a data leak happen, what would be their responsibility? Are they fall under the jurisdiction of PDPA, or they have some other things to deal with?
So it's difficult to say that a building do not fall under part of commercial transaction. The term commercial transaction is pretty weak for now. So even I have a business relationship with you, there's a commercial transaction. But when there's no business relationship with you, it's indirect. For example, I come to your building, I use your facilities, I meet somebody. Would that be considered as a commercial transaction when there is no monetary sum or many consideration involved? So then it comes to the question of fairness lah. These people collect data, they are not subject to PDPA, but they do not take steps to protect the data and end up, let's say they collect all your IC and so on and so forth, and then it gets leaked. So what happens? The PDPA does have a small exception where there is an unlawful processing of personal data. So for example, if let's say a staff caught hold of the data and takes it and go and sell, the PDPA will hit that staff. But as whether a building owner or the management of the building would be caught under the PDPA and be charged for it, so far there's no case. I also think that the PDPA would not be applicable because it is a criminal provision and it has to be strictly applied when it comes to criminal provisions.
Okay. Now, I'm also going to ask another question. Sorry, I have a lot of questions here, but I believe that some of these questions are relevant to our daily lives as well. So, assuming that we're going to visit someone, some of friends, some friends living in a gated guarded community, and then the guard will, the guard at the perimeter will stop us and then take our IC and then record the details into their systems. Now, sometimes they record it into a computer, so sometimes they just write it down and on a logbook lah. Then at the same time, they also ask us for our personal like phone numbers, and of course, when they have our IC, they have our address already. Now, all these things are being recorded into a logbook and into a computer system. And is there any precedence, like any of these kind of management get sued because they leak out, they have all these personal data leaked out? Because all these personal data are valuable.
Yeah. So far
when they
none.
get our IC, yeah.
So far none. No reported case as to whether a strata all this management committee were investigated under PDPA. So far, there are a lot of chatters about it, but no one actually has been charged for it. The commissioner, I believe that he has also come up with a paper to say that it does not apply to management committee. But you cannot say that because it's a non-profit organization, the PDPA does not apply. If they use the data, for example, and start selling it, then the PDPA apply because the commercial it becomes a commercial transaction there. So the fact that you collected it, even though at the beginning is not for commercial transaction, but you use it for commercial transaction, I would believe that the PDPA would apply.
Yes, I think this is also a very strong reminder to any organizations out there who are collecting personal data in. And let's say, for example, the building management, they collect the data, and then I personally have no idea how these data are going to be used later on, because every day you will have visitors coming to the building, and you let the security guards copy the data onto the logbook, and eventually, where are these logbooks are going? Are they going to destroy it, or are they going to do it, sell it, or I have no idea. But again, it's strong advice to organizations is that all these are liability, I would say. It wouldn't be an asset if you do not know how to manage them properly. So, okay, let's move on to the slides. We do have a lot of questions coming up about the timeline. So it's interesting to see that the law PDPA has been around for more than 10 years already. In fact, more than 15, close to 15 years. And last year only we have a revision. And the revision last year was quite interesting because it introduces some new concept. I wouldn't say new in the data protection realm, but in new to PDPA. So we're going to talk about these new concepts later on. And now I'll pass to Ching Long again about the 7 key principles about PDPA. So Ching Long, perhaps you can elaborate to us, what are the 7 key
Mm.
principles?
It's what I was okay, I will summarize it in very layman manner. First, in for general principle is that you will essentially need consent to process person data. There are two types of person data. One is sensitive person data, one is just person data. Uh, Sensitive person data is a special category of data. So it applies to data like your mental and physical health, whether you have any past offenses or alleged offenses, your religious belief. So these are the few categories of sensitive personal data. This will be applicable when you deal with employees. When there's an employee, you will need to collect, for example, first day is medical checkup. So medical checkup, you will collect sensitive personal data. So then when it comes to sensitive personal data, the differentiation is that the level of consent. So when it comes to sensitive personal data, you will need explicit consent. Explicit consent means clear and unambiguous consent. So essentially, it is a higher level of consent. Essentially, also in practice, what we do is it has to be in writing. It's very clear. We do not use, like, for example, implied. We will go and straight away say clear and ambiguous. It must be writing, clearly written to say that I consent to processing personal data. And so where you put all this consent clause is where at the time of collection of the data, when there's a letter, for example, you send, for example, employee again, you employee or potential employee sends a CV. When they send the CV, that is a form of commercial transaction already. You request the information, then you should provide what we call notice principle. When notice principle comes in, you give a privacy notice, a PDPA notice, whatever. There are a few names to it, a privacy statement, but essentially you need to comply with the notice and choice principle, the second principle. It has to be in both Bahasa and both in English. Basically two transactions, two uh, languages, and it can be provided through, let's say, a document. Two is by URL. You give a link, or you can email it, or you can send letter. So the distribution of it can be in many forms. Then once you collect data, for example, I give an example again. The employee, for example, potential employee comes in. The data you collected, you cannot simply send it out. For example, when they send it to you, you looked at it and say, this guy looks like, hey, it's good for my other company where I can sell them credit card. That is not in compliance with the disclosure principle. The data collected must be in relation of the purpose of the collection. If I give you the data for this purpose, you cannot use it for any other purposes. Then comes the security principle. Security, essentially, you just need to picture the data is properly kept, not misleading and up to date. You would need, sorry, that was integrity. The security would basically, there's no data breaches. And next slide.
Yeah, okay.
Retention principle. Okay, go back to the employee principle. Employee scenario again. The employer wants to collect, let's say, a CV, that the retention principle kick in. How long can you keep the CV for? Or for example, the employee comes in and then left the company thereafter. How long can you keep the data? Can you keep it forever? So in respect of, let's say, employee potential employee who sends you a CV, normally the retention period is 6 months. If you do not want to fire the person, you delete it off, unless the potential employee says that, yes, please keep it for future processing in the future, future application or future opening. So you can keep it forever. Whereas comes to employee who has left, there's certain information you keep, certain information you don't keep. For example, information about his MC, for example. After 7 years, the guy leaves. You know what? You don't need all his MC information. There's no longer any purpose. You delete the information. You destroy the information. So the key element in retention principle is whether there's any purpose to keep the data or not. And data integrity is to ensure the data that you kept is accurate and up to date. So another scenario is the employee gives you the IC number or gives you the bank account number for payment salary. As the employee, you must keep this information as accurate as possible because you do not want to make payment to a wrong account. So that's where the integrity comes in. And access means that the employee, for example, the data subject, what we call it, the individual can have the right to access the data. For example, and to collect to ensure the data is correctly stored, the data is not outdated. The only thing is, what more can the individual know? Can he know more than, for example, where do you get the source of the information from? The law does not provide for it. The law only provides very limited circumstances is to know, for example, what is the data you're keeping about me? I want to know. But for them to go further extra is to know where's the source. That is not part of the law. So essentially, that is the principle.
Thank you, Ching Long. This is very interesting because you're using a one same example to elaborate all the 7 principles. Now, I have a question here, which is, I think, also quite relevant to many people: retention. Because many organizations today, I mean, we keep records. We keep records almost forever. Like some of the employees who join and leave, and then some of the records are still with the organizations. Now, my question is this: for organizations who keep employee records, can the organizations have their own policies and procedures to 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 keep beyond what's the law required? Let's say the law says if the data must not store longer than necessary. Let's say I run an organization, and then my organization, because of due to some specific requirements or reasons, I want to keep the employees' data indefinitely for indefinite period. Can I do so by having my own policies and procedures? Question number 1.
Yes, you may. You want to keep certain data forever, but you will need consent, and the consent must be for a specific purpose. There are laws where you need to report, which you require to keep data, which, for example, the income tax laws, or employment law. To keep that, for example, if your employee leaves, for example, you would need to keep at least 6 years because there is a limitation period where the employee can take action. Where, for example, there will be also contentious issues that may come out. Let's say there's a lawsuit coming in soon. You may also keep it until the lawsuit is completed. Usually what we do is we have a policy, what we call a retention policy. The retention policy will be a category of all the documents, and then you set out what are the information that you can keep and what information and what is the retention period for each. So, for example, again, the employee CV, potential employee CV, you put there potential employee CV 6 months. Then you put it the application for leave for employee, then you put after 6 months, 6 years after employee leaves, or pay slip 6 years after 7 years after employee leaves. So you will need to determine. There are a lot of samples out there in determining the retention period, but it may not be applicable to you. And also be very careful because, for example, you take one from the UK. The UK one has very different requirements or different laws where you can keep personal data for how long. So in respect of UK, sometimes they have another provision for archival purposes. So archival purposes, they will have a certain period for it. But in certain places, they don't have that provision. Like for us, we don't have that provision. For, let's say, historical purposes, we do not have that provision. So you cannot go and say, oh, I'm keeping it because this guy has been with us forever, and then I want to keep everything about him. So you would also need to do what usually is done is the relevant personnel in the company. They will all sit down and say, okay, for this one, how long should we keep it? And then the guy, for example, HR will say, oh, I need it at least for 6 years. Or then the guy for accounts, no, I need it for 7 years for accounting purposes. So they will essentially all sit down together and determine what is the proper timeline to process the data.
Okay, so ultimately, you still need to get a consent from employee, letting him know that potentially we may keep your data forever, right?
Yes,
So the
if
employee, you must get a consent.
So, for example, if when it comes to forever, then you need a very specific consent for it. But for the normal daily circumstances, scenarios, you do not really need consent for to process data because so long you collect it, obtain your consent from day one, you can collect it or for the purpose or until the purpose is finished. So you do not really need the last consent to, the last consent is only required if there is beyond the purpose that you want it for.
Understand. Now, my second question is also very relevant to the principle about access. Now, a lot of the time, I think Malaysians, we're quite familiar. I mean, we've experienced this almost at a very frequent basis. Like people calling us, telling us that they want to sell us something. They have property agents calling us. There are insurance agents calling us. Now, as a consumer ourselves, right? How can we use this access principle to ask whoever is calling us about what else do they have about us? I mean, would this apply? How do we exercise our rights?
So the access principle will come about where you put in a written request and to ask them what information they have about you. But on the phone is a bit difficult because the guy who you speak to may not be from the company that they claim to be. Most of the
Mm,
time, these people what we call telemarketers. So
mm,
telemarketers are being subcontracted to third parties. So they will come and call and say, I'm on behalf of this insurance company, but in fact they're actually not. They're actually sales agent from the
mm,
telemarketers who are
mm,
contracted to do the work for them. So they may or may not be the employee. So they may be what we call again the data processor. So there's some question. The question is what's the difference between the data processor and what is data user slash controller? Previously, the law says that the word data user is to describe the person who collects the data for his own purpose. Now the name has changed to data controller. Then comes to the second layer is what we call a data processor. A data processor is the person who provides services to the data controller. Essentially, they are collecting personal data on behalf of the data controller. So who this data controller? Here is your telemarketer, your web hosting company, your email service provider. These are the people who are collecting the data on your behalf. So when you ask for requests from the data controller, the data um, the data processor will need to redirect you back to the data controller. So the data controller would have, if they comply with the law, would have a process where you put in your request through writing on the things that you want. So that is how it's done. But I personally have not done it. But it'll be interesting to test everybody and see if they can comply with it or not.
yeah, because sometimes I think the data controller could be a valid, legit business entity. It could be banks themselves, it could be insurance company themselves. It's a processor. It's a processor that is questionable. You know, sometimes they may get a batch of data from the data controller from a bank or insurance agency, but later they resell it to someone else or maybe to their colleagues, to the other, I don't know who else they sell it to. And then when these people call us, when these people contact us, that's where it's hard to trace back. Okay, I think there's a lot of interesting questions coming in, but let's continue on the slide first. Now, let's look at the latest amendment. You know, what would you like to highlight, to all of our audience here about the
Mm.
latest amendment?
So that's why I mentioned about data user being data controller. Essentially, it's just to update the name to an international compliant name. In the EU, they use the word controller. Somehow, when we came out with the law, we used the word data user. So perhaps at that time is to maybe controller seems to be confusing, but now they just updated controller. Two is data processor need to comply with the security principle. In the past, the obligation is on the data controller to make sure your data processor comply with the security principle. So what happened if, let's say, the data processor causes the breach? In the past, is the data controller who got the trouble, but now the law has been changed based on previous cases. A lot of times, is the data leakage happened because of the data processor
Yes.
causing the data leakage, and a lot of times is the data controller being outside Malaysia. So a lot of, let's say, the software development work was being processed or being done in overseas. That caused a few of these data breaches. So now the law wants to make sure these data processors get into trouble as well if there's a data leakage, especially if they are the one who caused the data leakage. Right?
Yes. Cross
And
border.
in the so there will be a cross border. So in the past is that if you want to process personal data, so you want to transfer personal data overseas, there's a set of requirements. This requirement in the past is that there's a white list. What are the countries that the government recognized to transfer data? But for 10 years, they did not come up with the white list for unknown reasons. So now they've changed the law to say that if the law is similar to our PDPA, then you can transfer it to places that you want overseas protection. But there are also other provisions, like for example, you get consent, or the country, or you sign some form of confidentiality obligation that they will take care of data to transfer data. But if there is none, you can always rely on the law that is similar to the PDPA. There are a few places that are similar: EU, Singapore, Hong Kong. Essentially, the Commonwealth countries similarly would have this kind of provision. And how do you determine whether they are similar to a PDPA? What you do is that you what we call a transfer impact assessment to determine whether the place has similar laws or not. That is maybe quite difficult, but then that is one of the ways you can do it. But the most easiest way is just to get consent from the data subject, the individual, to transfer data overseas. Then the next one is the expansion of sensitive personal data. Now they included biometric. So your facial recognition data, let's say you go through a system to recognize your face, that the biometric, sorry, that is the biometric data, and it becomes sensitive personal data, and therefore you will need your explicit consent. All right. And the compliance, the penalty has been increased to 1 million, and then the jail term also has been increased. But so far, nobody has been fined the maximum. And in respect of the fines by the court, there's actually not much, usually 5 digits. No one has gone to the 6 digits yet. And most of the time, I also seen no cases where the person has actually fought the case all the way to the end. Most of the time is they either pay a compound or they just plead guilty and pay a fine. And now by effective 1st June, by this month, you need to appoint a data protection officer. It can be internally, it can be external, but essentially that person need to make sure the company complies with the PDPA. That person will need to be quite involved in the business of the company. So later you will talk about it. Yeah. Then there's a data breach notification. If that's, let's say, more than, I think that's the threshold of 1,000 data being leaked, you will need to make sure to notify the commissioner within, I think, 72 hours, if not mistaken.
Yeah, 72 hours. Yeah.
Of a data breach to the commissioner. But then if it's and then there's a right to portability. Right to portability is essentially is transfer one data to another. You would think about, for a very clear example, is your phone, your mobile line, is to transfer your information from Maxis to Telcom or Telcom to Maxis. So that is the right to portability. In respect of telco, is very applicable to that. So these are basically the new changes in 224.
Okay, good. Thank you very much, Jing Liang. And I think that summarizes very important points about the updates. And also here, we also list down a list of guidelines, such as circulars that everyone should be interested in to find out more details about the 2024 amendments. For example, the first one, DPO appointment guidelines. Then within the guidelines, you get to see what are the recommended best practices and suggestions. So these, I think I saw some of the questions here, and these questions could easily be addressed from just referring to the guidelines. There's also another important point is the data breach notification guidelines, and talking about the requirements. And somehow I still think back to the Cybersecurity Act 2024, because as part of the requirement for critical national information infrastructure operators, they need to notify the authorities as well. There's a requirement for them to notify the authorities, which is quite stringent. It's within 7 hours of the discovery of the breach of the incidents, and within 14 days, you have to submit a report. So this is kind of, I would say it's kind of similar, but especially when you have a cyber attack case where it involves personal data leak, where it involves critical infrastructure downtime, I think this is going to be very interesting. So Ching Long, let's say an organization, they belongs to CNII, assuming they are a bank, for example. So a bank suffered data leak. Personal accounts details were leaked out, and including personal data, and they also govern under the Computer Crime Act, Cybersecurity Act 2024. So if you are if you're the legal advisor, what would you suggest them to do in sequence?
Okay. When it comes to data breach, the bank unfortunately has a lot of processes to go through. Under the Cybersecurity Act, it's within 6 hours, I think,
6 hours, yes, sorry, yeah.
6 hours, and then the PDPA within 72 hours, and then
Yeah.
the bank negara also, I think you need to notify them.
Yes.
So I think within 6 hours, 6 hours is the short. Right? The bank negara requirements, I'm not sure how long the timeline, but once there's a data breach, you will need to start working within less than 6 hours. You need to
Mm.
start doing all the
Yes.
activity.
Yes. Technically speaking, I think from our experience working in computer crime cases and hacking cases and ransomware cases, when you discover an incident, cybersecurity incident that involve downtime, that involve even potentially data leak, um, you would have, you have deploy your incident response processes in even less than an hour, and that is because of the business criticality. I think 6 hours, in my opinion, is quite lenient actually. Um, so nevertheless, let's continue on this one first. The guidelines, so everyone can take a snapshot of this, and this is quite useful. The formal mandate for data breach notification compliance. And okay, what it meant for business, I think this is a critical part. For business, what do we need to pay attention to? Okay. So with the PDPA, it established clear accountability. Business need to take personal data seriously. Um, I think personal data, a lot of the time, we always have the impression that those data that store in our computers, those data we collect and store in Excel form or any PDF or document forms. But in reality, the data that we collect may not necessarily in computer form. It could be in physical form as well. Like some of the examples we've discussed, building management, security guards, who are keeping the data in the logbooks, and all this also establish accountability that we need to manage this data carefully. Um, Aside from this, Ching, would you have anything to add on? Sorry.
Mm, sorry. So far, all most importantly, what it needs to be done is impact assessment. A privacy impact assessment, we'll call it, is how the PDPA affects your organization. And now with a lot of new laws and requirements coming in, other than the things that we just shared just now, there are actually more coming up soon. There are actually proposal paper being presented already to the public. And this will also come soon. There are actually a lot of this proposal paper that came about. Even I have no time to look into it. So you essentially need a very dedicated person or company to take care of your PDPA requirements. In the past, the legal counsels have been moonlighting to comply with PDPA. But now, with the requirement under the new law, you will need a DPO, a data protection officer, to take care of it. You can say that yes, I'm going to just get one of the legal counsels or one of the IT guys to moonlight, but now you can't. The work is so much that you will need a dedicated person to do the compliance, especially if you are dealing with a B2C type of business.
Yes, B2C type of business. This is very interesting. That brings up the point of DPO, Data Protection Officer. Now, as part of the new amendments requirement, organizations need to have DPO. But what kind of organizations do we need to have DPO? Organizations that process
Mm.
personal data? It means virtually any
Yes.
organizations or only specific sector?
Um, there is a specific requirement. I can't remember
Mm.
the exact number. There's a certain exact number where the requirement of DPO needs to be appointed. So if let's say you're running a very small business, you don't need to go and register. Let's say a law firm like me, you don't need to have a DPO under the law to comply with law. I can appoint it based on my personal basis. I can apply. I can go and appoint one, but it's not mandatory for me. So
So
under
it's
the law,
voluntary lah,
voluntary.
voluntary.
But under the guidelines, it says that if you have more than 20,000 personal data, so let's say you are a property developer, you are B2C business, or you are in the retail online e-commerce platform, the PDPA would have applied to you. And if let's say you are running a clinic and you already have 10,000 um, 10,000 patients and you keep all the personal data, then you need a DPO also. So these are the few requirements where a DPO has to be appointed to run the business.
Assuming there's another question. Assuming I'm a clinic, I'm a small clinic. I have less than 500 patients, right? Is there a need for me to, by law, is there a need for me to get a DPO?
No, you do not need to get DPO at a small scale. In fact, you should look into the guidelines on appointment of DPO.
Mm,
It sets out all the requirements. It sets
mm.
out the basic requirements. It sets out the thresholds, which the PDPA, the DPO provisions will apply. Should
Okay,
apply.
good. Yep. So this is also a very frequent asked talk about subject because now it's June already, and then the appointment of DPO is actually mandated by June. Okay, so another thing is let's talk about the best practices. I see a lot of questions coming in still, and which is very good. So let's quickly go through the content we have here. So best practices again, I would say for any organizations, regardless what you have what kind of business you are in. I think most importantly, you need to have policies and procedures in house. That provide guidelines, guidance for the employee, for the entire organization to follow. Bare minimum must have policies and procedures. If you do not have any policies and procedures, there's no way you can communicate a unified message to different layers of your organization. So in terms of data protection, policies and procedures must be in place at the first place. Then secondly, I would say once you have a policies and procedures, of course, we need to create the awareness to roll out the requirements in the policies and procedures to every layers of the organization. Awareness training, very important. And then subsequently, you want to make the process sustainable. You need to conduct regular assessment to ensure that whatever being practiced, whatever being carried out, are comply to the policies, and there's always consistencies are being maintained. So conducting a regular assessment. I can only share this is a general way how information security is being managed. Now, coming from data protection, of course, there are more stringent, more granular actions you can do. There are multiple ways you can protect data from applying products, buying data leak prevention products, implementing certain controls in your network, in your end user's desktop, installing certain EDR protection software, locking down your firewalls, limiting the rules, or what kind of website is accessible and not accessible. There's a lot of things can be implemented from a technical standpoint. So engage experts who can advise you on your requirements, and also it's also that's why it all boils down back to the bare minimum. Do you have a policies and procedures regarding data protection or not? If you don't, you need to start drafting it already, right? Otherwise, you can forget about being compliant to PDPA or any other kind of business. Even running a business today without data protection policies is very risky, at a very high risk. So, Ching Liao, do you have anything to supplement on this or to add on this area?
No,
Both of you.
I'm answering all the questions. I'm trying to answer all the
Yeah,
questions in the Q&A box.
yeah.
So far, what you have stated is quite comprehensive. Um, I think once you do the compliance exercise, you will know what else you need to do,
Mm,
because compliance assessment will tell you what are the gaps in your organization.
yeah.
Of course, you can do it internally, you can do it externally, with a DPO or without a DPO. Whatever it is, you should do the compliance.
Yes.
Otherwise, because it is important, because in the event there's a data breach, the one of the things that a commissioner will ask you is, have you done an impact assessment? Have you done an audit on your own system to show, things, have you done reasonable steps to make sure that your organization is PDPA compliant? So if you say that you have not done any, then you will suffer consequences of not doing so lah. But if you're,
Yes.
let's say you've done all your best, then the commission will say, oh, okay, you've done all your best, you put in the best effort, you put in a lot of money, but yet it still happened. The commissioner may say, okay, I'll just give you a slap on the wrist, give you a compound, or ask you to give the undertaking not to make sure it doesn't happen again. So,
Yes.
these are the compliance is actually very important. And if you think that it won't happen to you, uh, trust me, a lot of my clients will say, I thought it wouldn't happen to me. So
Yeah.
you make sure you need to do necessary first.
Yeah.
And
Same goes
and
with cybersecurity incidents. Many people
correct,
don't think
correct,
hackers will
correct.
attack them.
And let's say if you're an employee, you say that, I'm just an employee, that won't happen to me. I'm not a DPO. I'm not the management. Unfortunately, you will lose your job if you're the one who caused the data breach lah.
Mm.
And it had been cases where the employee were fired, dismissed, or gone through public humiliation because of those breaches.
Yes, and also to extend what you've shared just now is also very important because the commissioner will ask you for evidence. Have you conducted your compliance assessment, the risk assessment or not? Of course, most of the time people will say yes, and then subsequently what the commissioner will request is the evidence because they will not just ask you whether you have done it or not and how well you have done it. They will ask for evidence. Now we have been working with many organizations when it comes to cybersecurity, data breach, and ransomware attack. In many cases that we have experienced dealing with the commissioner together with the client is that the commissions, they're also very sharp. Sometimes the commissioner, they themselves, who are the one who notify the victim saying that, hey, we have seen this in the dark web, someone or some authorities, for example MCMC, have shared with us, we saw your employees data exist in the dark web, and how do you explain this? So they are not really that passive as we perceive. There are people, there are members of the commissioners are quite active, and then they got sources of leakage from the authorities, the regulator authorities like Bank Negara or MCMC. So they will contact the victim and say, explain to me about this. And then when the victim says, yes, we have done our risk assessment, we have carried out penetration testing, we have carried out vulnerability assessment, and all of this information were being asked, by the commissioner and say, okay, show me all your evidence. We want to go through it. And based on our real life experiences, they will ask for such evidence. So it's not enough just saying that, hey, yes, you have done our assessment, we have done our audit, we have done all these things, but be prepared that you will be asked for the evidence. So, which is quite interesting that the way how we saw they operate, even until recently, one of our client who happened to be the victim of a ransomware attack, the hackers managed to hack in, and also publish some of the stolen data onto the dark web, and that's how the authority found out and notified the commission, and the commission went after them. Right, so they are not as passive as we thought actually. So let's go to Q&A. Right, so I think we have a lot of questions coming up here. So let's just go through. Some of these questions have been addressed also by Jing Liao earlier. So government, does PDPA applies to government?
No, PDPA does not apply to government. But, there's a specific exemption in the law to exempt them from the application.
I think the same applies to Cybersecurity Act, the penalties and all this.
Mm.
Yeah. Okay, this is a bit sensitive. What's your take on the recent MPD initiative from MCMC? You don't have to answer me if you don't want to answer.
Well, I have to answer this because I have an interview tomorrow on this requirement. Well, the commissioner, sorry, the MCMC themselves has said that I'm only asking for anonymous data. So when it comes to anonymous data, okay, yes, it's good, anonymous data. Then it comes to how it is being processed, how the whole structure is like. Someone in the telco is going to crunch the whole thing and give it to MCMC. So when that particular data that is being anonymized, is the question is how is it going to be done? Let's say it's going to be, let's say, 5 million data inside. Someone has extract and convert it into data that the MCMC wanted. I think so long is anonymous data with MCMC, that is fine. But when it comes to your individual listing of people, this number belongs to this person, this number belongs to this person, I think that is something we must object, because we do not know how well these people will deal with our data. We had
Mm.
in the past, where there had been data breaches from the telco side, also due to the involvement of MCMC asking for data. As some of you may remember, many years ago, our own minister, Fahmi Fazil, had actually, when he was still in opposition, actually sued the MCMC and sued the telcos for the data breach that happened. That case,
Mm.
unfortunately, was withdrawn after that. That was many years back before even he became a minister, or even he was very active as, I think, on the upper part of PKR at that time.
Mm.
So I think personally, okay, asking for data, statistic data should be no problem. It's
Yes.
only is what is the data being shared.
Mm.
And unfortunately, the law, being licensees of the MCMC, they have to comply with whatever
Yeah.
whatever request. And I
Mm.
understand that in the past, they actually did ask for data of use subscription data of certain individuals. That of
Yes.
course happened before lah.
Yeah, I think a lot of Malaysian nationals still cannot get over with, including myself. I cannot get over with the massive data leak that happened back in 2017. You know,
Yeah.
40 over millions of 46 million Malaysian phone numbers, including personal data, home address, serial numbers of the phone, IC numbers, and all these data were leaked because of this massive data transfer based on MCMC's requirement. Now, the case was quite interesting. I'm looking at the case details here, and if anyone is still interesting to know about this case, you can do a Google search on Numera data leak, right? And then it will bring back the history. And that's a reason I understand why many Malaysians are still uncomfortable when MCMC is asking telco to share the data. I think this is still a shadow that haunting
In
us
fact,
until
In
today.
fact, the Nurema dispute is still ongoing until today. If I'm not
Mm,
mistaken, there had been a termination of the agreement,
yeah.
where Numera was supposed to do a certain project. The agreement was terminated, and therefore an arbitration has commenced, and there were
Mm,
lawsuits going in and out. So
uh,
after so many years, it is still ongoing today, until
Still
today.
going. Yeah, that's the thing about Malaysians. Our trust on our government's ability to manage sensitive data. I mean, of course, the continuous hacking of government departments, all this news also doesn't help in boosting the confidence of the general public towards the authorities about their ability to manage sensitive data. But echoing with what Qing Long is saying, there's more interesting guidelines about data protection is coming up, and I think one of the interesting thing is the national ID. National ID is a totally separate topic. I think this is also pretty much concerning to many of us Malaysian. Let's go back to the questions here. For the DPO appointments, is it for all? I think this one is answered already. For the DPO role, do you think it should be a first liner or second liner within the organizations to take up the role?
Well, it's the first liner. When let's say a new product rolls out, the DPO should have the say in how the thing is going to be launched. So let's say e-commerce platform, if I'm going to launch it. The DPO should be involved in the whole process. What we call privacy by design, is to ensure that whatever you design has to think of privacy in the first place. So one of the things is, what is the data being collected? Are you going to collect excessive data? You ask for his home address, ask for his mother's name, and so on and so forth.
Mm.
So when it comes to process personal data, you also need to it has to be limited.
Yes. Yeah. So that brings us to almost the end of the session already. We really talk about PDPA for 1 hour. So the last message we want to share is about our DPO services, data protection officer outsourcing services. Now, these outsourcing services, basically, we get a lot of requests coming from our client because we have been working in the data protection and also cybersecurity arena for the last 20 years. So a lot of customers actually came to us and asked us, hey, what can I do in terms of DPO role? Can we outsource? By law, you can outsource, but definitely we have certain requirements for the client. If they want to outsource, we have certain best practices can introduce to clients and help the client to facilitate the entire outsourcing process smoothly. So if you're interested, if your organization is interested to know more about DPO outsourcing and how LGMS can help you, do drop us a link, or you can go to our website, lgms.global. You can take a quick assessment, and then from the quick assessment, you get to know how ready or how what's the necessity for you to have the DPO role in your office. So we have this on our website. Just go to lgms.global, and also, and yeah, this is what I was referring to. Go to our website, and you will see this survey. Now, now we have approaching the 1 hour mark of our presentation. Do we still have any questions? If not, then any final conclusion, Jing Long?
I think it's 1 hour is sufficient given the questions that's coming in. Of course, any questions you can ask CF and approach LGMS for it. Then perhaps we can have a little chat after that. So yeah, I think that's all from me for now. I'm on LinkedIn, so please add me. If you've got questions that are here that you want to divert to me, please you can add me on LinkedIn and ask me questions there.
Yeah, thank you, Ching Long. And something I noticed very interesting for this webinar today, because we have 118 active participants right now, and the 118 has not changed for the last 1 hour. It means that the topic's really concerning everybody, and everybody is really interested to know the in-depth about this topic. So I think everyone here, the team members here who prepared the slides, and Ching Long also, everyone deserves a big round of applause, including our audience who stay throughout the entire hour together with us.